Okay, good morning. Welcome everybody to our webinar today on GDPR, a certainly hot button topic, if not necessarily the most exciting one, but we're going to do our best to break it down for you here and touch on the key points, and hopefully you can come away with a better understanding of the overall regulation, or if you're already familiar with it, a few strategies that you can embrace to strive towards GDPR compliance. So, allow me to introduce myself. My name is Adam Gaydosh. I'm the Director of Security Intelligence here at Anitian. I've been in the industry security-wise almost 20 years, as well as overseeing our different practices. I'm a principal consultant for a lot of our GRC work, so I'm pretty heavily involved in the regulatory compliance space, hence my involvement here with GDPR and being the one that gets to plow through the European regulation, which is a riveting read, I assure you. But we'll try to break that down a little bit later perspective than the legalese that it is written in. So I've been at PCI QSA for almost 10 years, do a lot of work with AWS PCI compliance there. We have a workbook if you do any work there that people seem to find to be pretty useful, and I helped develop a risk assessment methodology that we use here at Anitian based off of NIST 830. So a little bit about Anitian here. We'll keep this light, but our vision and our mission is that we do believe that security is essential to growth, and what we're trying to do is we're trying to build great security leaders and practices and programs, and we've been fortunate to work with some really great companies and security leaders throughout the industry, and of course many more than are on this particular slide deck, and I'm sure many of you. So brief overview of Anitian's practices. We have 5 core practices that we offer services in. Risk Now is our risk assessment practice. Vision Path is our audit and assessment, regulatory compliance. GDPR, we'll need a bullet point here. Ring Zero is our pen testing, more broadly than just network pen testing, as you can see, of course. Sherlock, this is our cloud security practice, and so we do managed SIM. There's a product that you can buy. We could manage it for you. Detection response, our forensics work is through that practice as well, the Sherlock team. And then lastly, vCISO. This is our governance, leadership as a service practice, and actually within that practice we do offer a service in support of GDPR, the VDPL, and we'll talk about what a DPO here is a little bit later for those of you who are not already familiar. So just a little overview of my intent here today, which, as I cited, is really to just give you a basic overview of GDPR and talk about strategies that we're recommending for complying with GDPR based on our own work and feedback we've gotten from our clients who have started down this path, in some cases well in advance, but the reality is, with it being in effect coming up here next year, a lot of people are really only just now starting to get serious about it. And so we do have some in the trenches feedback from those that got ahead of things. And so we'll share some of that basic outline here. We're going to go over the basics of GDPR. I highlighted a few of the requirements that I found to be the most significant or notable, either from a level of effort and impact perspective or changes from previous privacy regulations. And we talk about, of course, the compliance strategies, what are the best ways to bite into this pretty meaty privacy regulation that has some real complexity to it, and probably more frustrating, I would say, is some ambiguity. So we'll try to cut through all that and come up with some tangible action items that you could take. I just want to say that GDPR is a really big and complex topic. This is going to be a fairly light overview when we talk about the basics here and some of the requirements that I cherry-picked of significance from me and feedback from our clients. So it's certainly not going to be an extreme deep dive on GDPR, but we hope you leave with a much clearer understanding and some good takeaways. So that being said, let's just dive in. What GDPR is this General Data Protection Regulation. It's an EU regulation that is focused on privacy. It replaces the EU's Data Protection Directive, which is from the mid-90s. And one point of note there is that this is a regulation versus the old one was a directive, which is not as enforceable. So really, right off the bat here, just the way GDPR is framed, it has more teeth from an enforcement perspective over the previous EU privacy regulation. It's focused on personal data of EU citizens, quite simply, helping enforce their rights and making sure that companies and organizations that have the EU citizens' data, or data subjects, as they are referred to throughout the standard, that their rights are maintained and enforced through this privacy regulation of their personal data. As I mentioned, this goes into effect the end of May next year. And it's all about data privacy. So this is really about having some very specific and frankly broad-reaching requirements concerning data privacy of EU citizens. Now, one of the first things that people ask us about GDPR is, I'm not a European business, so why should I care? Because it's a European law. Why would it apply to me? And so the short answer is that it probably does. Obviously, there are some conditions there, but it's certainly not limited to EU companies. It absolutely, of course, does apply to EU companies and those with EU citizens' data, those offering goods and services. There's a few other criteria to those that would fall under GDPR. But if you have access to any type of EU citizens' personal data or offer goods and services to them, then this is going to affect you whether or not you're actually headquartered in the EU or not. Also, monitoring the behavior of EU data subjects, that would fall under GDPR as well. So, and of course, as I'm going to talk about here in a moment, the real crux of the issue is the fact that it applies to the personal data of EU subjects, which, as we'll talk about in a moment here, is rather broad. So there are, however, let me just quickly explain a concept that is pretty fundamental to GDPR, which is the organizational categories that they have, which comes down to two simple buckets of either controllers or processors. Now, I've seen some confusion where people think of a controller as a specific role, like a financial controller within an organization. That's not what they're referring to here. This is a general category of organizations that would have personal data, in the second category being processors. And really the basic distinction or way to think about it is that the controllers are the people ultimately responsible for the personal data. They're generally the ones that actually collected the personal data from the EU citizens. And then the processors are people that perform some operation on behalf of the controllers, effectively service providers. And vendors is a simple way to think of the distinction there. So controllers are ultimately responsible. Big difference here, though, over the previous regulation is that there are now specific requirements for processors that were not as explicit as they were in the past. So I talked about this applies to personal data. This is a real important thing to drill down on a bit here, because the definition that they use for personal data in the GDPR is very broad. It really expands what many people would consider to be your classic personally identifiable information, PII, as we like to refer to it here. It, yes, of course, includes those types of things, name, address, date of birth, etc. But where it really gets to be a little bit surprising to those that are new to GDPR is things like photos, email addresses, posts on social networking websites, and IP addresses that could be identified back to the person are considered their personal data. And so the reality is, while many businesses that had privacy programs in the past or even reasonably mature information security programs that included data classification mechanisms and then managed risk based on the data classification, which is of course a best practice, they many times would have a personally identifiable information classification, but very rarely, if ever prior to GDPR, did I see that including things like a photograph or an IP address of that user. So this really opens up the definition of what personal data is, and ultimately this is a data regulation, and so that really has significant implications because these regulations apply to this broadly defined set of personal data that many organizations are going to have of EU subjects, and in some cases even identifying that is going to be a real challenge from a technical perspective. So so there's definitely some work to do there, and we're going to dive into that a little further down when we talk about strategies. Sensitive personal data is another category. They have, it's also sometimes referred to as special categories of personal data within the GDPR, and effectively these are things that are a little bit more sensitive, obviously, than your average date of birth type of thing, which is an identifier, but not to the same degree as the more the items that people are much more commonly sensitive to, such as your health information, financial information, your race, sex, religion, etc. You know, the first step here is you first have to identify, am I a controller? Do I somehow actually get this information from somebody? A basic example would be like a Facebook. I'm going to use them because there's a lot of speculation when we talk about the enforcement that's happening, is going to happen, that probably the EU is going to try to make an example and go after some of the big players. So Facebook, for example, would be a controller because you actually provide them a lot of your personal data as part of your profile for social media, and then they are going to have a huge number of different organizations that are going to be handling that data on their behalf in some manner, and so these would be the processors. You know, for example, analytics for advertising and marketing that would be using your data that Facebook collects and controls on your behalf that they'd be sharing with processors or their vendors and service providers. So you can imagine the task of them having to identify all the European Union citizens' photographs and IP addresses, categorizing this, inventorying it, and then figuring out who it's shared with amongst their various vendors. This starts to become really difficult really fast. But I don't want to get too far ahead there and scare you off. I just wanted to give you a nice tangible example of what that looks like. So we talked about what this is and who it applies to at a very broad level. So let's talk a little bit here about certification and enforcement. I'm going to start with the penalties because there's a lot of consternation over this. Quite simply, the penalties are potentially massive. We're talking, it is defined explicitly up to 20 million euro or 4% of your worldwide annual turnover. That's your revenue, not your profits, from the preceding financial year, whichever is higher. So I did some back of the envelope math for Google last year, and I think that would have been something like, I think it was 4 or 6 billion US that they would be getting fined based on their 2016 global annual revenue if the regulatory authorities, we'll talk about the supervisory authorities, if they found them to be non-compliant under the criteria that results in the highest fine. It is a tiered approach to penalties, so there's a lot of specifics, tons of caveats throughout this standard based on if you're a controller or a processor, and where exactly you were negligent in complying with GDPR. But ultimately, the cap there is 4%, which is big. That has a lot of people concerned, obviously. And it's really underscores the fact that the EU means business with this. They had the old directive there since the mid-90s, but it was not super enforceable, and so they made this a regulation. They gave it some serious teeth with some very explicit fines and much broader definitions of personal data and much more specific obligations to protect the privacy and the rights of their citizens' data. So certification now is something we also hear a lot of questions about, and it's defined in Article 42, and I'll talk a little bit about the structure here in a moment. The long and short of it, though, is that it's not fully implemented yet right now as far as how you would actually get officially certified of saying, I am GDPR compliant, because it's the obligation of the member states. And we're going to talk a little bit more about what the structure looks like, but this is an EU directive that then is implemented by the individual member states. Although there is some reference to ISO when they talk about certification bodies, and so that is presumed to be the likely model for certification. And I'm going to talk about ISO throughout this as far as what we see and others in the industry as a real advantage of leveraging an ISO compliance program, 27001 specifically, for GDPR compliance, and why that makes sense. Not the least of which would be getting ahead of that potentially being a mechanism for certification. So let me talk a little bit about some of the other basic concepts in the structure of what GDPR is. So I referred to the article there a moment ago with the penalties defined in Article 83 and certification in 42. And what the articles are, these are basically the top level requirements that are numbered throughout the regulation. There are 99 of them. And then they have subcomponents, usually a handful, 6 to 8. So you might see something like Article 7 parentheses 3 as a reference to a specific clause within the GDPR. So these are basically the top level requirements. And they are categorized into chapters throughout the GDPR. And so they define quite simply what it is. So you'll hear a lot of people referring to the article number, and that's just the required number is the easiest way to think about it. Another thing that is really important here, because this is still an evolving standard, it's evolving in the sense that the implementation is evolving. The regulation is law, and that is it. But the way the laws are written is they're fairly broad so that there is, so that it can be implemented appropriately amongst the different member states. And so these recitals are these officially documented guidance, interpretation, implementation information that you see. It's actually, there's online versions that you can find in the GDPR that link specific articles to supporting recitals, which are updated as the implementation evolves. And so those are really important references to clarify things. For example, there's one in reference to certification explaining how it is the member state's responsibility to do this and that they should, but the reality is they haven't yet. So you've got the articles, and then you got the supporting recitals, which are a little bit more dynamic and kind of clarifying where things are at, the state of affairs for a given article, or just the GDPR overall. Supervisory authorities. So this is ultimately the this is the regulator, the regulatory agency responsible for GDPR, and the way it is structured is to be a supervisor authority for each member state. Now, there is a lot of talk about harmonization here and having a single supervisory authority that you can work with rather than having to potentially work with one in each member state within the countries within the EU. But ultimately, the way it's structured is that each member state has responsibility for the implementation of GDPR within their country and will have their own supervisory authority. But when you see that reference to supervisory authority, we're talking about the regulatory agency or agencies that are overseeing this. Pseudonymization, fun little word there, that is an important concept that I just wanted to touch on lately here. We'll talk about it a little bit more lately, but I get a lot of questions about it. It's referred to in the standard as a means of helping to secure personal data. And really the easiest way that I find to explain it to people and that I think about myself is very similar to tokenization. If you're familiar with tokenizing financial data or other sensitive data, where you have something that is basically a representation of the data in some mechanism that you then have a way to look up what the original data is. In some cases, it's a totally abstract version. In other cases, it's like a redacted portion of the original data. But that's what they are talking about there, is a means of sanitizing data without encrypting it or some other mechanism, but in a way that could be looked up or reversed. And there's some specific requirements around those types of implementations. So just a question I get quite a bit, and I wanted to talk about that in here. So let's talk about, though, some of the notable requirements here that really jump out to us as being impactful from an implementation perspective, or are big changes from previous privacy regulations. There are many others that you're likely to find to be impactful within the GDPR. Let me make clear, this is by no means an exhaustive list, but we only have so much time today, and so I wanted to call out the ones that we've seen the most concern amongst our clients with. And so here they are. So we're going to talk a little bit about data protection by design and default, designation of the data protection officer, the right to erasure or the right to be forgotten, the breach notification requirements, and then the records of processing activities. So let's just drill down on these here if we can. So data protection by design, Article 25. This is really the big one here, as far as this is so foundational to an entire compliance program being effective, is all predicated on the successful alignment of your GDPR compliance program with Article 25. And so this is where you're going to need to inventory and classify all of that personal data. And as you recall, when I talked about how broadly defined personal data is within the GDPR, that is not necessarily a trivial task. And so the big companies that are feared to be more likely in the crosshairs of the regulators come May 25th, that started this 1-2 years ago, they're telling us that this has been very, very difficult to feel that it's comprehensive. And in fact, it's really something that is an ongoing task for them. And so the strategy here, and we'll talk a little bit about this more later, is that is to start with what you know. And so it really starts with doing that business process inventory and analysis and mapping that back to data flows and then looking for it for there. And of course, the very important piece not to overlook, especially if you're a controller, is identifying all the processors, those vendors and third parties with whom the personal data is shared as part of your overall inventory and data classification scheme. So Article 25 is a big one. There's a lot of work to be done here. We're going to talk a little bit more about strategies in that further down. So the next one here is the DPO, the Data Protection Officer. So this is a new mandate in GDPR as well. And effectively, this is the person that would chair your compliance program or oversee it at your organization. There are a few caveats here that that it needs to report to the highest level of management, is what they refer to it as. So it's not as simple as your classic, let's say, director of compliance within an InfoSec team or something. It needs to be higher up from that. And so it explicitly allows for outsourcing. We're seeing a lot of organizations doing that, unless they're really, really large organizations. They're going to have somebody at that top management level as a direct report as a full-time DPO, but certainly those exist as well. There are plenty of them, and that is a ripe career field right now if you're so inclined. But that being said, a lot of people are outsourcing this for that reason. I think I alluded to that our vCISO, leadership as a service, has an offering in support of GDPR specifically, and that's what it is, the virtual DPO. But the important thing is to know what it's responsible for. So it oversees the program quite simply, and provides advice on what the obligations are, helps oversee and coordinate the implementation, and then ultimately is the point of contact with the supervisor authorities, in particular concerning breaches, which we'll talk about later, explicit responsibilities in regards to breaches. And then also they oversee what's called the Data Privacy Impact Assessment, which also I will talk about later, which is a specific activity unique to GDPR. DPOs are explicitly required under specific conditions. They're pretty broad. It's not every single organization, but it's a fair amount. And really, from our perspective and talking to our clients and our peers, really, if you're concerned enough about GDPR in the first place as applying to you, and you being concerned about being able to demonstrate compliance, then designating a GPO is highly recommended, whether or not you maybe don't meet the explicit criteria, of which there are quite a few and are fairly broad nevertheless. So next one I wanted to call out here is the right to erasure. Article 17, the right to be forgotten. Okay, quite simply, if you have my data and I want you to delete it, you have to do so. If I make that request, you've got to delete all of my personal data. And you have to do it within 72 hours. So I talked about earlier about how there are penalties for non-compliance, and it's a very tiered approach based on specific violations and other infractions. And so this would be an example of one not meeting the Article 17 right to erasure and responding to a request in a timely manner. And so you can start to see, this is a great example of why the inventory is such an important thing to have, because if you don't know where all of the personal data is and don't have your processes in place to be able to quickly access it and respond to the different requirements that you have concerning requests of various types within the GDPR, one of which is the right to be forgotten, then you're not going to be able to meet this requirement, if potentially by not knowing where all of the data for the person who requested it actually lives, and that means potentially your processors as well. And so this is a pretty significant requirement within GDPR. One thing that's worth noting here is that controllers are required to assess if there's some reason that they might deny a request to be forgotten by somebody, which is really, it's defined as something to the effect of in the public's interest for that data, which, you know, I'll let the lawyers get prosperous off of advising you on every request which one meets that criteria. But an easy way to think about it would be for some type of crime, for example, or potential crime where somebody's trying to cover their tracks by requesting you delete data. And I'm sure there's many other instances as well. I guess the other thing I just add here, in addition to the right to erasure, it also includes more specific provisions regarding the right to stop sharing and processing of data, if not erasing it outright. So this is a big one, but really the crux of the issue here is you've got to be able to respond to these within 72 hours, which means you need to know where it all is and have your processes defined to be able to respond in such a timely manner and not face fines. So the next one here, that's another one of big concern with many organizations that we talk to, is breach notification. So there's two articles here primarily that touch on breach notification, 33 and 34. Again, this one is time gated, so that speaks to the seriousness of this regulation, and that they are giving you very little time for some of these requests, 72 hours. And there are two points here. One is the fact that that you have to disclose it to a supervisory authority. Okay, so these are the regulators within the member states, and this is the DPO's responsibility. I talked about how the data protection officer has specific requirements. That would be one, notifying of a breach. And then also, in certain cases, you have to disclose a breach to the actual data subjects. So, if my information, if I was an EU citizen and my information was breached or compromised in a breach, then I would have to be notified under certain conditions. And so that also includes processors having to notify this information to controllers as well as to the citizens themselves. And so I'll talk about those conditions here within some degree, but the important thing to note is that what is considered a breach is much broader than many of the U.S. requirements, for example, of a breach that really focuses on if the breach is going to result in some type of theft or fraud. Here again, GDPR is broader. You can see the quote there. I don't need to read it to you, but it's well broader than if the actual result of the breach is some type of theft or fraud, but just if there is actually some type of disclosure, access, or modification, etc. So that's the first point. The second point that's a major concern and shows the fact that until this is really implemented and we see how the supervisor authorities are going to start reacting and what certification process looks like, no one's really sure, but there's a lot of debate about what actually constitutes discovery in the first place. When they say you must disclose a breach within 72 hours of discovery, there's strict interpretations of this that basically say when you are aware of the breach, your first notification, right? So you have your security operations team. They are monitoring all of their security events and other sources for potential incidents that they would investigate. And as you're familiar with the incident response process, there are many events and investigations that occur that are not actually breaches, but nevertheless have gone through some steps within the IR process. And of course, some of them sadly do result in a breach where you need to implement the full incident response process. Now, the question is if they're talking about as soon as you have become aware of that first event, those first tells that, oh, we might have a problem here, well, that could be a huge difference in the timeline between when you first were alerted to an issue before when you finally came to the conclusion that yes, it is a real breach versus no, it was not, it was a false positive or some other type of incident that was not an actual breach. And many times that might take more than 72 hours. So there's some consternation over how aggressive you need to be with the disclosure to the supervisory authorities. A more pragmatic view, of course, is that 72 hours discovery means actually confirmation that there is a breach, not notification of a potential breach by a antivirus alert or something to that effect. Nevertheless, it is a point of discussion that we get asked about. Our peers are talking about all the time. People are really waiting to see what happens. And it speaks to the fact that this is still a little fluid, having not been implemented yet. There's some specific information needed to provide as part of breach notification that again speak to how important the inventory is and understanding what data you have, what its categorization is, and what you're doing with the data. So this includes you actually have to disclose the records themselves, the number, and the categorization of what these different data records were. You also have to talk about what the likely consequences of the potential breach would be and what your response and mitigation would be to this. Now you don't have to, the DPO doesn't have to provide that all initially in the initial notification, but nevertheless there are additional reporting requirements beyond just simply saying, hey, we've been breached. You need to talk about more what does it mean and what are you doing about it from your perspective. So a lot to unpack there, but the bottom line is this one has people concerned because, again, we talk about the fines for noncompliance and having this tight timeline, and people are not even entirely sure when the clock starts running. You could see how that could cause some real duress. So for this and everything else that is still not super clear, it's why Anitian advocates so strongly for taking a risk-based approach to the GDPR, which we'll talk about a little bit later here. So you can really demonstrate that due diligence and then be able to respond as things are fleshed out and the interpretations and implementations occur next year. So let me keep it moving here in the interest of time. Our next one I want to talk about is Article 30. So this is the records of processing activity. So this is another one that is hugely important in that it is conditional for so many other effective processes to comply with the other articles, such as the breach notification, is that you have to have, in addition to your inventory and your classification, for all of the instances of data processing you might have, which could be huge numbers of different activities that are processing data, which is very broadly described. You have to have specific information documented around it, as you can see here on the slide. And so this is really, this gets into vendor management is a huge part of this. You have to be able to understand what your vendors, processors are actually doing with data that you share with them. Of course, validating that they meet the standards within GDPR. But this really speaks to the continuous monitoring and reporting of processing. And so when you talk about this continuous type of monitoring and validation of activities, that really aligns with some of the core components of ISO 27001 and an information management system. And is another example of why people are really advocating for using that as a baseline for complying with GDPR. So I would just add here that the burden is really on the controllers to monitor processing activities, make sure their processors are compliant, or at least meet that standard of sufficiency, which we'll talk about, including that the processors understand their responsibilities concerning subcontracting. Again, GDPR does define specific requirements for processors, but nevertheless, the controllers are ultimately responsible for that. So let's see here. Moving on, let's talk a little bit about the strategies. We gave you a high-level overview of GDPR, some of the core concepts, and some of the big points of contention, the things that have people scared. And you can see, really summarizing that, it's that there are some very broadly defined concepts of personal data and breaches, and some very significant implications for noncompliance from a financial perspective, as well as potential business impact, which I'm going to talk about in the context of compliance strategies and program priorities if you're not compliant, and how that might impact your ability to do business with organizations that are GDPR compliant, or at least are pursuing it and more mature in that program development lifecycle than you are, and are therefore requiring it of their business partners, some degree of evidence. So a lot of significance here for non-compliant entities potentially. So which really means you need to know what's the best way to start down this path and become compliant. And so that's what we're going to talk about here, as well as leveraging ISO, as I've alluded to, is a strong thing. So I just want to quickly here, I want to talk about at a high level what a good compliance roadmap looks like. This is, there are some specific activities here, of course, that we have called out in for GDPR specifically, but for those of you familiar with compliance program management, implementation of compliance programs, a lot of these high-level activities are pretty standardized across many other compliance regimens. And again, not to beat the drum too hardly here for ISO, but obviously you should recognize some core components of an ISMS for those of you familiar with ISO 27001. So, starting with the formalization of the actual program itself, step one, you need to get it off the ground. And as I alluded to, that DPO is a very critical step there in almost all cases. you also, of course, there's more to it than just that. You need to have your stakeholders identified. You need to get your resources allocated. This is going to take budget of some sort. You're going to need people at the very least. You may need technologies. You may need contractors. You may need consultants. So you need resource allocation as well as the stakeholders, not just the DPO, who is ultimately responsible for overseeing everything. And all of that ultimately, most critically, means you need to have that buy-in, right? And so for those of you that are security practitioners that maybe are concerned that you're not getting the buy-in that you need for addressing GDPR, if you think it is something of significance and potential significant impact to your organization, but perhaps top-level management doesn't see it that way, then we strongly advocate, as we do in almost every instance of a similar situation, that you take a risk-based approach, conduct your risk assessment, and be able to speak to the executive management in the context of business risk, as we like to say here at Anitian, the so what that a CEO might say when you come into his office and say in utter panic that you're not GDPR compliant and you're nowhere close and it's a big problem. And when they ask you, so what, to be able to speak in the business terms as to what the actual impact might mean to the business and why it matters. And we find that, and then be able to support that with data, of course, from a risk assessment. The fines, the potential impact in relationships with third parties who no longer can exchange data with you because you don't meet that sufficiency required of GDPR. So formalizing the program is a very important foundation, of course, but it's from there that you actually start doing the work. You have the buy-in, you have your stakeholders, you have your budget. So now it's time to dive right in. And there's really two main activities to get started here. It's to start that data inventory and do your risk assessment. The data inventory, as I said, is a really pretty significant effort, and I'm going to talk a little bit more about some of the strategies that we recommend for that. But since all of this applies to the data itself, it has to be inventoried, it has to be classified, and you need to get going with that as soon as possible. And then is the risk assessment, which is such an important way to, of course, get the buy-in if you haven't already completed it. And much like for those of you familiar with ISO, the risk assessment should be used to define what your control set is going to be. And so we've seen other organizations start with a gap assessment prior to their inventory. That's a lighter controls analysis, and then come back once they have the inventory and doing the risk assessment. That's certainly an approach that can be considered as well. But ultimately, you need to have that risk assessment conducted to know where your gaps are and then augment your control framework appropriately. And I would just add here that companies we've been speaking with that have had the most success from a buy-in perspective have really leveraged that inventory activity and risk assessment activity to socialize the whole GDPR compliance program and create awareness around it. Because you can't do a data inventory that is modeling business processes without talking to the owners of those business processes. And the same goes for any type of risk assessment that is not just some type of automated self-assessment or technical scan, which certainly people call risk assessments, but it's not what we're referring to. We're talking about a facilitated risk assessment here, where you're discussing and analyzing probability impact of threat occurrences in regards to known vulnerabilities. So that's the time to get to socialize and start. You have the buy-in from the top. Now you're pushing the buy-in down the stack in the next second phase here. The third key phase would be the risk mitigation itself. Now that you've completed your inventory, you've conducted your risk assessment, you know what controls need to be put in place, it's time to implement those. You're going to find, of course, that it's your standard mix of technical, administrative, and physical controls. One thing I think some people are surprised to realize how much process documentation is required to be able to demonstrate compliance. When it comes to things like like eraser and consent, which we haven't talked about yet, but we will, and the right to access data, breach notification. There's some specific actions that you must be able to support on request of the data subjects. And you need to be able to have processes documented to implement that, and actually then document that it occurred and prove that you're actually doing these things. So definitely some administrative controls are likely to be in your future. And I know how much everyone loves writing policies and procedures, but the reality is it's going to be an important aspect here. So reducing scope is another activity to consider. It is not something that is super trivial to do, just by virtue of the broad definition of personal data. So where we're seeing entities be most successful in scope reduction is in the proliferation of the data throughout their organization, the processors and third parties they're sharing with it, trying to rein that in. The data sets themselves generally are required for the business process, and those can't necessarily be shrunk easily in many cases, and some certainly, because you are expected to evaluate the necessity for collecting the information. But ultimately, in most cases, scope reduction comes more from the number of places a data set might live throughout your environment and your vendors. And then finally, you've got everything in place, you've got your control framework. Now it's time to evaluate this and optimize, right? So this is effectively right now we're talking about self-certification because there's not a formal process yet. And you could perhaps fold this into your ISMS if you want to get audited as part of your ISO audit. Whether or not that will be sufficient ultimately is to be determined, but seems like a likelihood. But nevertheless, this is the time to validate that you are compliant, enhance any controls as necessary. You could reevaluate your scope. I talked about data necessity, retention and disposal of data. And do what you can to demonstrate sufficiency of compliance. Conduct the DPIA. I'm going to talk a little bit more about what that is in a moment. But effectively, this is a GDPR specific risk assessment, as I find the best way to think of it, that helps evaluate compliance with GDPR and optimize your controls. So priorities and pain points here. This is the next lessons learned from the trenches kind of section I want to talk about here. Priorities, we have a couple. These are the things that have the highest return on investment in regards to complying with GDPR from our perspective. And then pain points, some of the items that we've gotten feedback from our clients and our peers, clients, concerning trying to comply with some of the various articles and requirements within GDPR. So we'll start with data inventory and classification. I've talked about this already in regards to what it is and why it is so foundational to being able to meet basically all the other requirements. But really the best way to tackle this is start with mapping those data flows of where you expect the personal data to be in the first place, and then translating that to the technical requirements. Just identifying all the business processes that have personal data, that alone, that effort can be pretty big. But again, that's an opportunity to start socializing the efforts. Big important step here is to get this inventory and classification going. When we talk about classification, we're talking about the actual types of records that you have concerning personal data. So we talked about date of birth, name. We talked about some of the special categories of personal data that would exist, such as your race or your sexual orientation. And so you have some discretion in how you categorize and classify the data that you have. It could be as broad as personal data and sensitive personal data. But in many cases, people parse it out more specifically in order to comply with some of the requirements for reporting. A note I have here, This is just an observation. People have talked about it. Not sure exactly how necessary it's going to be, but we talk about identifying the member state of the data subject themselves. So to take it one step further and say these are all of the names or date of births that we have of people from Europe versus these are all of the ones from France versus Germany versus Spain. The reason is because it is up to the different member states to implement GDPR. And they already have somewhat different interpretations based on their own existing privacy laws that in some cases supersede GDPR. Now, luckily, they don't contradict each other yet as far as everyone can tell. That's the good news. And so the basic play is to go with some of the strictest interpretations. France, Germany, and Spain, if I recall correctly, tend to err on the side of strictness. But obviously, there is, of course, the potential, hopefully not, that there might be some contradiction, and then that would be a real nightmare having to have different levels of controls applied to different citizen states. Not trying to fearmonger here. It's been discussed. I thought I would throw it out there. I certainly wouldn't start with that level of data inventory and classification, or certainly wouldn't prevent myself from moving forward having not performed that. This I can keep in mind. And the last thing is, this is an iterative process. So start mapping the data where you expect it to be based on business processes, and then move forward with the rest of your program. And then as part of optimization, you can start looking for processes to do data discovery for personal data that is located somewhere it shouldn't be or wasn't known or expected to be. And then from there, you can decide what to do with it, scope reduction or elsewhere. And so that's going to be an ongoing task. Again, speaking to the ISO concept of continuous improvement and optimization, the inventory classification is going to fall in that type of activity. So let me keep it moving here in the interest of time, which is quickly running out, of course. So much fun to talk about. GDPR, I'm losing track of time. So risk assessments are something I've talked about already. As I mentioned, there are a lot of places where it's interpretive. They use a lot of terms like sufficiency and timely manner. And so anytime we're talking about some type of standard with those decision points, having a well-documented risk assessment goes a long way in demonstrating due diligence in the event that someone contends with your interpretation of one of these somewhat ambiguous terms. And of course, it's a great way to evaluate the appropriateness of the controls you have and those that you need. And that, of course, also follows the ISO ethos. So now let me talk a little bit about the data protection impact assessment. This is a GDPR specific activity defined in Article 35, and really this is about validating that you're compliant and specifically what the risk of the processing activities that you have are. It's required for controllers. Many processors use it to demonstrate sufficiency to their controllers. It's not required explicitly, but it's a really commonly used activity for those even that are not required to perform it. And this would be intended basically almost as a self-assessment after you've implemented controls. And really what you're talking about here, part of the risk analysis of how high risk a processing activity is will include things like evaluating the necessity of the activity, the processing of the data, what the risk is to the data subjects of that processing, and are your controls sufficient for it. So let's talk about some pain points here quickly before we wrap up. So consent is a big one here, big change in that it is no longer implicit to agree to your personal data. I'll use the Facebook example. I certainly don't remember reading some long document and then explicitly signing my name and dating and everything else to give them my personal data. That's no longer the case. You need to have the implicit or opt-out type of consent. Certainly is no longer acceptable. They have two different tiers, if you will. They call it unambiguous for the personal data and then explicit consent for sensitive data. But they talk about specifically examples of even unambiguous. You've probably noticed on a lot of websites recently, you're getting these privacy notices pop up that you had not seen before, requiring you to provide consent for them to keep a cookie or on your computer and harvest information about that. That's generally in response to the consent requirements of GDPR. Consent have to be in plain language as well. And I guess the last thing I would add here is that it's required for children by their parents, which could be a real headache for how do you actually ensure that you have legitimately gotten consent from parents of their children. Again, you have to be able to track how you're doing this and demonstrate compliance. It's not insignificant. So moving on here, cross-border transfers are another one. Big question we have about this. Yes, you're allowed to transfer data outside of the EU. However, there are specific requirements on when and how you can do that. And so there are a handful of articles, 44 through 48 or 49, that talk about the specific requirements. And basically, they are in cascading layers of cost and complexity to be able to transfer to an entity outside of the EU or a member state based on the conditions. So the most basic one, 44, if I recall, Article 44, talks about how if the country has been deemed adequate by the European Conditions Commission. So the adequacy, they publish all the countries that are listed there. Basically, are their privacy laws adequate and reasonable that you could transfer data to them comfortably? And the U.S. quite simply is not on that list. And so then from there, you have to start walking down through the next couple layers of conditions to find which one might be met by the entity you're trying to transfer this data to, and then make sure that they have met the conditions specified for those entity types. And it includes things like contractual obligations, these things called binding corporate rules, BCRs, and so other legal type of obligations that, again, your cost and complexity is going up. And certification, however, is one of them that is in that list. And so, again, this is a call for where ISO compliance might be a way to demonstrate sufficiency for U.S. companies to entities that are saying, I can't even share this data with you anymore unless you've demonstrated sufficiency. And we talked about business impact and getting buy-in. Well, that's a big one if suddenly everyone in Europe who you do business with stops sharing data with you because you can't demonstrate sufficiency. So profiling is the next one I want to talk about briefly here. Basically, what these are rules about any automated decision making that happens in regards to GDPR personal data. Really trivial example would be like an online credit application that you're denied based on some business intelligence rules without any type of human review. The focus really here is on the decision itself, not the processing of it per se. You have subjects have the right to object to this type of profiling. You have to be documenting what is profiled and notify the subjects of this profiling, how it occurs, what the logic and consequences are. So again, talk about having the inventory and then having really clear documentation and understanding even internally before you can share with third parties what you're actually doing with that data. Profiling comes into play there. And there's some contention over what constitutes profiling that I don't have time to get into necessarily, but some people are interpreting it extremely broadly. But we think the pragmatic risk-based approach, as usual, is the way to go. So we're about done here. I'm going to quickly, I've talked about ISO 27001 quite a bit as a way to start down that path towards GDPR compliance. Obviously, there's some very specific components of GDPR that they're not required by 27001 and the ISMS requirements, or even the 27002 rule set. But there are certain components of it that I've listed here that, as I've already mentioned, tie right into strategies for GDPR. And then lastly, I would just note that mostly the companies pursuing ISO 27001 compliance are those that are doing business internationally and likely to be impacted by GDPR anyway. And as a way to maybe provide that sufficient guarantee of data security if you're a U.S. company. So final thoughts here, start with that DPO and formalize your program. Get your data inventoried. Start down that process. It doesn't have to be perfect, but get that first pass going so you can then do your risk assessment, roll out your controls, and it's a DevOps world now, right? So publish and iterate. Just get started, get something out there. It may not be perfect, but it's better than nothing, and then just keep circling back and continuous process improvement until you get where you need to be, and you can provide that assurance to your business partners and to any regulators that may ask it of you. So I'm sorry that we did not have time to go over the questions, but we'll make sure that we reply back to everybody who submitted questions, of which we have a few, of course. It's a very complex subject. I recognize that. I have a blog post that just went live yesterday, actually, that touches on this. It's a little lighter in some cases, but it's certainly a reference. There's lots more out there. We'd be happy to talk to you, of course, about any questions or concerns you have in regards to GDPR. My contact information is here, and the presentation will be published on our website, as you can see. And so thank you for your time. Really appreciate everyone joining us today, and I hope that helps you understand better GDPR and some strategies for achieving compliance.